When I'm asked about terminating a design or construction contract, I like to joke with my clients that it's a little bit like defusing a bomb. And I think about those 80s movies where the bomb squad is, huddled in the parking lot and the clock is ticking down, and, we got to make sure we cut the red wire, not the blue wire. And the reason why I make that joke is just to carry home the point that there's a lot of risk in terminating design and construction contracts, and it's not something that you want to do lightly, and it's not something that you want to do without a lot of thought ahead of time. Because what you find running through most cases that reach a lawsuit, is the court looking at the question of who breached first. And a lot of times you'll get an aggrieved party and they'll say, oh, my contractor is taking so long, I'm going to terminate them. And you got to take a step back and you got to say, okay, has the delay, just as one of many examples, risen to the level of a material breach, something that would justify the owner in terminating the agreement between the owner and the contractor? Because the question of who breached first is going to typically dictate the outcome of the case. And so, if I was asked to assess that, I would say, let's look at the contract and see what it says about schedule. And a lot of times there's, very light language around, schedule, and it's not elevated to the level of, something that is of the essence of the contract. It might be the case that, there's just a completion date and there's nothing along the lines of, and the contractor understands that the owner has a tenant, they've signed a lease, they have to get the tenant in by a certain date or they're going to breach their lease and lose their tenant. So you have to look at the contract and you have to assess, is the thing that you're contemplating as a justification to terminate the contract, does it rise to the level of a material breach of contract that would justify your terminating a contract, or is it a lower level breach, a minor annoyance, something that wouldn't result in a proper termination of contract, something where if there was a lawsuit, the court would say, who breached first? Well, the owner's legally operative act of terminating the contract, the judge might say that was the first breach. And that is how, an owner or a real estate developer can open themselves up to claims that they wouldn't want to face. Because if you unjustly terminate a design professional or a contractor, how are the damages measured? It's different in every state, and there's a lot of nuance here. But generally speaking, it is possible for an improperly terminated party to say that I want the benefit of my bargain. I want expectancy damages. I plan for a year's worth of construction. I plan to make this profit. I set aside my staff and they didn't take on other projects, and so I want to make the profit that I would have, and there may be some other measures of damages that go with it. So if you cut the red wire instead of the blue wire when you're terminating the contract, sometimes the act of termination can be deemed to be the first breach, and it can be deemed by the court to be the thing which actually subjects the terminating party to a winning claim for damages, rather than the terminated party being the one that loses in the end. So there's a couple of practical considerations that you need to think about too if you're contemplating terminating an architect or an engineer or a contractor mid-project. And one is, how are you going to complete the job? Does that party have sub-consultant agreements beneath them, subcontract agreements beneath them? Are there subcontractors or design professionals that are working underneath the party that you're planning on terminating? Do you need them to continue working? Does your contract give you the right to step into the terminated contractor's shoes and take an assignment of these sub-consulting agreements or these subcontracts? What about intellectual property? If you're terminating a party that may have sub-consultant or subcontract agreements, who owns the intellectual property that all these people produced, in connection with the project? If the answer is that they do and the owner does not, if the owner, a real estate developer hastily terminates the contract without thinking these issues through, they could find themselves in a situation where the project could grind to a halt. And then, again, you got to think about, do you have justification to terminate? Is the breach material? And that is, most cases, going to be dictated by what the contract says. So, if you're thinking about terminating a contract, you got to read the heck out of the contract. And sometimes not just the contract itself, but any other contract documents that might be incorporated inside. So, an agreement between a general contractor and a subcontractor may very well incorporate certain provisions of the prime agreement between the owner and the contractor. So you got to get your arms around what the contract is, and you got to read it. You got to assess whether the breach is sufficiently material to justify termination. Then you got to ask yourself, what are the contractual provisions around termination say? Are there notice requirements? And notice requirements tend to be fairly important when it comes to design and construction contracts being terminated. And it can vary depending upon who is deciding a fight between two parties over whether a termination was right or not. If you are in court and you're dealing with a judge might be very legalistic and take a very narrow view. It says in the contract here that if you want to terminate, you shall give this notice a certain number of days. But if you're in arbitration, and maybe you're dealing with an arbitrator who's an experienced design and construction attorney that is interested in doing job site justice, rather than necessarily taking that very legal view that a judge might, perhaps the arbitrator might be less concerned about whether or not you gave notice as required by the contract, precisely right. Usually what notice comes down to is the question of prejudice, right? So if you are thinking about terminating a contractor's contract or an agreement between you and an architect or an engineer, if you don't give them notice, it says, hey, I don't like what's going on here and you better fix it, or I'm going to terminate you, then a lot of times the question is were they prejudiced by the lack of notice? And if the answer is yes, they were prejudiced, because had they been given the notice, they would have straightened up and flown right. That is one of the important factors that sometimes a judge or an arbitrator would look at when deciding, whether or not a justification was whether termination was justified, or whether it was an improper termination, and then, if so, how do you measure the damages that flow from it? So if there is a right to cure in a contract, if there are notice provisions, it's generally the best practice to try to comply with them as strictly as you can, bearing in mind that sometimes they will be strictly enforced and other times they will not. And then, when you put together the letter that says I'm terminating your contract, you really want it to be a skilled termination letter. It's not just the sort of thing where you throw a couple paragraphs into a letterhead and you fire it out. Back when I was working at, the large law firms, when we were thinking about terminating a contractor, we would have multiple of my partners, working together to weave together the right kind of argument, and this is, again, diffusing the bomb in the right way. It's not cutting the red wire when you're trying to cut the blue wire. There's art here. You might, be wanting to put things in that says that, hey, you breached, and without me waiving any of my rights, I'm going to give you a chance, to come back and fix it. There's a way to sort of fit yourself for the white hat and fit the other party who you're trying to terminate for the black hat. Because if a court or an arbitrator is going to look at the question of whether termination is justified, they're going to look at the termination letter, and so it's a good idea to put, your best foot forward. And there's definitely a skill to it, in terms of putting something out there that is going to be well received by a third party, a judge or an arbitrator, in the event that there's ever a question about whether the termination was proper. But there's also some skill in writing a letter that will induce the response that you want from the other party. And if you're worried about, maybe I don't want to diffuse the bomb, if your letter induces the other party to do something legally operative, like perhaps terminate you or walk off the job, not in every circumstance, but in some circumstances there's an advantage there. So, when you are putting together that termination letter, you want to do it with a lot of thought. You want to consider the facts. You want to consider the law. You want to consider the contract. You want to fit yourself for the white hat. You want to comply with notice provisions, and you want to do what you can to avoid an argument that you're terminating them for an immaterial breach, or that if it does rise to the level of a material breach, that you terminated them in a way that prejudiced their ability to cure, or whatever else might be appropriate under the circumstances of the contract. And you got to think about, what are the stakes likely to be? If you're terminating a large construction contract, in the middle of the project, are you going to be holding back a significant contract sum? Is that going to lead to lots of mechanics liens? Is that going to lead to litigation, right away? You have to sort of think about, how, what's next? And it's not just completing the project, it's, what happens with the terminated party, what happens with the other agreements they have for the project. And so, I use the analogy of, terminating a design or construction contract being a little bit like the bomb squad trying to defuse the bomb, making sure that you're cutting the wire that you're trying to cut and not the other one, and making sure that you don't cut the right wire a second too late. There's definitely a skill to it. Sometimes you'll see in a construction contract a clause that says that, if I terminate you for a cause, if I argue that, you did wrong and I get to kick you off the project, and later a court or an arbitrator determines that I was wrong and I didn't have a basis to do that, sometimes you'll see a contract clause which says, under those circumstances, if it is determined that I was wrong in terminating you for cause, then the termination is automatically converted to a termination for convenience. Typically under construction contracts, there are for-cause terminations and for convenience terminations, and usually one of the differences is if you get a for-cause termination wrong, the way that the party that was improperly terminated can measure their damages can be much more substantial. If there is a for convenience termination, there's typically language in there that says that if the owner decides to terminate for its own convenience, this is what is recoverable by the contractor. And so if you have one of those savings clauses, you could sometimes convert an improper termination into one for convenience. And in some instances, an owner or a real estate developer can have essentially a parachute or something that they're able to use when the plane starts to go down and to make it be not as bad as an outcome. But the takeaway here is that of the many dangerous things that are done with design and construction, terminating an agreement between an owner and a contractor or an architect or an engineer is one of the things that is very risky, and you definitely don't want to do it casually. You don't want to do it without a lot of thought and attention in advance to make sure that if you are going to take that step, that you are able to get the outcome that you want. That could be the completed project, avoiding liens. It could be making sure that the other party is not incentivized to bring litigation against you. And in the event that there is that litigation, making sure that you're the party that's fit yourself for the white hat. And in the event that it turns out that someone determines that you're wearing the black hat, do you have a contract clause that converts the improper termination for cause to one for convenience? So lots to think about here. A design and construction attorney, real estate attorney, and many other kinds of attorneys could help you get a termination for cause right if you have decided that that is in your strategic best interest to terminate the contract.